Contract offers can be accepted by promising, performing, and even sometimes by silence. Hi, I'm Professor Seth C. Orenberg, and today we're going to talk about contract formation, acceptance by performance. As you know, contracts at law require three things: offer, acceptance, and consideration. In other videos, we've talked about offer and consideration, and today I want to drill down on a specific aspect of acceptance. How can acceptance be made? There are three ways or forms of acceptance. Three ways that offers can be accepted: by promising, by performing, and in unusual cases, even by silence. An offeror may invite or require acceptance to be made by an affirmative promise in words, or by performing or refraining from performing a specified act. And sometimes, though not ordinarily, even silent inaction will be effective as a mode of acceptance. Acceptance by silence will be discussed in other videos. Today, we're going to focus on acceptance by performance. Sometimes the offer is limited to acceptance by performance only. Language or circumstances sometimes make it clear that the offeree is not able to bind himself in advance of a complete performance. His promise may be worthless to the offeror, or the circumstances may make it unreasonable for the offeror to expect a firm commitment from the offeree. In such cases, the offer does not invite a promissory acceptance, and a promise is ineffective as an acceptance. Such offers, where a promise will not accept the offer, are called unilateral offers. Examples of unilateral offers are found most often in offers of reward or prizes in a contest. Let's look at a simple illustration of a unilateral offer. Please read the screen. Seth publishes the following offer: I will pay $1,000 for the return of my dog who was lost yesterday in Frick Park. Talia sees this advertisement and at once sends a letter to Seth saying, I accept your offer and will search for your dog. There is no acceptance. This is an example of a unilateral offer. The manifestations and the circumstances of the offer make it clear that the offer can only be accepted by performance. A promise will not do. After all, Seth wants his dog back. He doesn't want to promise to search for the dog. Since the offeror is the master of the bargain, he can make an offer that limits acceptance to performance only. Here, this is a unilateral offer, which can only be accepted by performance. Therefore, a promise to perform the bargain is not an acceptance. Let's try another illustration. Please read the screen. Seth publishes the same offer. I will pay $1,000 for the return of my dog who was lost yesterday in Frick Park. Talia sees this advertisement, goes to Frick Park, finds Seth's dog, and returns him home. Now there is acceptance. Talia has performed the contract. In this example, she has completely performed, and that constitutes acceptance of a unilateral offer. Please remember, however, that most offers are not unilateral. The common, ordinary commercial bargain consists of a bilateral offer, which invites acceptance by a promise or performance, or sometimes, in rare cases, even by silence. In the ordinary commercial bargain, a party expects to be bound only if the other party renders the return performance or binds himself to doing so. A party can bind himself to rendering a performance later, either by express words or by beginning performance of the conduct. Again, the ordinary course is a bilateral offer. Unilateral offers are more exceptional. Let's look at an illustration of a bilateral offer. Please read the screen. Seth says to Talia, if you dog sit tomorrow, I will pay you $20. Talia says, I'll do it. There is acceptance because Talia promised to perform in the future. Note that Talia could also have accepted by performing, by actually dog sitting. This is a bilateral offer. It can be accepted either by promising or by performing. Now that we understand how most offers permit acceptance by promise, performance, or sometimes even silence, and we understand that unilateral offers limit acceptance to complete performance, let's look more deeply at acceptance by performance. There are 3 stages in performance: preparing to perform, beginning performance, and completing performance. Each stage has its own legal effect. Preparations for performance. How is merely preparing to perform distinct from actually beginning performance? The distinction between preparing for performance and beginning performance may turn on many factors: the extent to which the offeree's conduct is clearly referable to the offer, the definitive and substantial character of the conduct, the extent to which it is of actual and prospective benefit to the offeror, as well as the terms of the communication between the parties, their prior course of dealing, and any relevant usage of trade. Beginning performance. If the invited performance takes time, the invitation to perform necessarily includes an invitation to begin performance. What is begun or tendered must be part of the actual performance invited. The next example will make the distinction between preparing to perform and beginning performance more clear. Complete performance is usually a simpler analysis. Complete performance occurs when the offeree has done everything that the offeror specified in the terms of the offer. Let's look at an illustration to elucidate these distinctions. Alex offers Brian $1,000 to paint his fence. What happens next? First, Brian goes to Home Depot and buys paint. Next, Brian applies the first stroke of paint onto the fence. Third, Brian completely paints the fence with 2 coats. When did performance begin? What was merely preparations to perform? What constituted complete performance? Most people would agree that putting the first stroke of paint on the fence definitely constituted beginning performance. But what about buying the paint? Whether buying paint constitutes beginning performance depends on other factors, such as, does Brian typically buy this paint for his work, or was this purchase of paint uniquely in response to Alex's request? Was this paint a common color, which could be used for any project, or was it specific to Alex's project? Could the paint be returned or readily reused for a different job, or is this paint only useful for Alex's job? As you can see in this simple example, distinguishing between preparing to perform and beginning performance requires an analysis of the facts and circumstances. Let's bring this all together and determine what is the legal significance of these distinctions between preparing to perform, beginning performance, and completing performance. First and foremost, preparing to perform has no legal impact. Merely preparing to perform does not constitute acceptance of a bilateral offer, nor does it create a quasi-option contract that makes a unilateral offer irrevocable for a reasonable time. However, as we will learn later, a party who prepares to perform may have a remedy in equity or quasi-contract. But for present purposes, in terms of the formation of a contract at law, preparing to perform has no legal impact. Beginning performance of a bilateral offer functions as an acceptance, so long as the offeror is reasonably notified of the offeree's action. Beginning performance of a bilateral offer is therefore tantamount to a promise to complete performance. Beginning performance of a unilateral offer is not an acceptance of a unilateral offer, because by definition, a unilateral offer can only be accepted by complete performance. However, due to the equitable doctrine of part performance, beginning performance of a unilateral offer creates a quasi-option contract at equity, which makes the offer irrevocable for a reasonable time. Completing performance, like beginning performance, constitutes acceptance of a bilateral offer, so long as the offeror is reasonably notified of the performance. And, as mentioned above, completing performance of a unilateral offer is precisely how a unilateral offer is accepted. So, completing performance constitutes an acceptance of both kinds of offers. So there you have it. This chart explains the legal impact of preparing to perform, beginning performance, and completing performance with regards to bilateral and unilateral offers. The hard part is distinguishing between merely preparing to perform and beginning performance, which requires a careful analysis of all the facts and circumstances. Thanks for joining me on this video about contract formation, acceptance by performance. I hope it helps you in your legal studies. See you next time.